but you tell me if that's a mistake, okay? Oh, it started, so.
I started it.
Okay, I'll leave it alone, right? So, Council, good morning. This is a time set for oral argument in our case number CV19-0813, Plea versus City of Phoenix. We have reviewed the record, reviewed the briefs where we've conferenced the case. We'd encourage you to keep that in mind as you present oral argument. Appellant does, or each side, pardon me, does have 20 minutes, and I'll look to appellees as to how you want to split that time. That will be kind of up to you. We will keep track of time actually in a low-tech phone that I will keep here. If appellant wishes to reserve time for rebuttal, you're free to do so, Mr. Doran. You need to keep track of your own time if you want to do that, and I'll keep track of time as we go along on my own little phone here as well, and I'll let you know if you do reserve some time for rebuttal where I have you kind of on that, so you can plan for that. Our proceedings are being recorded, obviously, so I'd encourage you when you do present, if you start with your name and the party that you represent. So with that, Mr. Doran, you may proceed.
Thank you, Your Honor. May it please the court, my name is John Doran, and together with Matthew Hesketh and Lindsay Hesketh, I represent the appellants, the City of Phoenix, and Ed Zerker in this appeal. My plan this morning is to devote roughly 15 minutes in my opening discussing the case with you, reserving 5 minutes for rebuttal, and yes, I will keep track of my own time. There is, of course, substantial briefing before you, all of which raises numerous substantive issues that can't be canvassed in 15 to 20 minutes. For our purposes this morning, my hope is to discuss the standard of review in this case, provide some examples of the overwhelming amount of individualized inquiries posed by the claims in this case, and discuss very briefly the notice of claim defense with respect to plaintiff's damages claims. If I may turn first to the standard of review. Typically on appeal, a court will review the trial court certification of a class for an abuse of discretion. However, the court will review the decision de novo when the trial court fails to dutifully follow the Rule 23 framework. We believe the trial court's rulings ran afoul of the Rule 23 framework, and it requires de novo review by this court. I think the starting point here is what I think is best described as the trial court's 60,000-foot view approach to certification. The trial court relied very heavily on an oversimplified summary of the case to support its legal conclusions. That summary states that there are collective bargaining agreements that created a promise. That promise was accepted by these election forms, and the only question, according to the trial court, is if the city could revoke the promise post-election. Yes, the trial court is correct. This case involves MOUs or collective bargaining agreements, and it involves election forms, but that's not the sine qua non of plaintiff's asserted claims. What the trial court did here with its 60,000-foot summary is precisely what Duke said cannot be done. The trial court relied on an overly simplified, overly general description of the case to conclude that trial by extrapolation is fair. That falls outside of Rule 23. The trial court certification order was indescribably cursory. For example, it concluded that Rule 23B1 certification is appropriate in a single sentence. It ignored the many reasons why that should not be the case. In other paragraphs of the order, the court simply restates the 60,000-foot summary of the case, then recites or borrows language from the rule and states nothing more.
Mr. Doran, let me interrupt you there. I do want to hear more about the 23B1B certification, but and the court issued, as I see it, 3 rulings on this. An initial minute entry, which ran about 7 pages and dealt with some other things as well. But then weren't there subsequent orders that were submitted that the court entered trailing a couple dozen pages describing the analysis?
Well, yes and no, Your Honor. There were orders issued after the certification ruling that were submitted as forms of order by the respective plaintiff groups. The trial court signed those. Those were largely lifted directly from the minute entry ruling. There's nothing new in there other than a peculiarity and perhaps another example of where the trial court didn't engage in a rigorous analysis, where the trial court granted B2 certification to the Clark plaintiffs when they hadn't asked for it. Other than that, they're mostly the same. It's not as though the trial court entered a minute entry, then went back and performed its rigorous analysis.
And let me ask you on that point, what is your reading of the record on what provisions of 23B that the Clark class relied on?
We believe that the Clark class relied on 23B1 and B2 and did not request relief under 23B3.
And that squares with my understanding. I think I misheard you. I thought that you had mentioned that the Clark class did not seek certification under B2. But so thank you. Please proceed.
I apologize if I said otherwise.
No. We understand each other.
Proceeding forward with respect to what the trial court did in terms of its summary approach, it gave credence to and relied heavily on conclusory, foundationless assertions in the named plaintiffs' declarations. The assertions include the named plaintiffs' repeated assertions that they personally knew what was in the minds of hundreds of unnamed plaintiffs when those unnamed plaintiffs elected to spike, and what those unnamed plaintiffs supposedly would want out of this action. Bearing in mind that there's literally not a shred of evidence from a single unnamed plaintiff anywhere in this record, the trial court also failed to address the named plaintiffs' own discovery responses, which directly contradicted the court's 60,000-foot view.
Is it your position that the class members each needed to provide information to the court before a class could be certified?
Not necessarily, and as you know, Your Honor, in a lot of these cases, what happens is the named plaintiffs submit declarations, but they also submit sufficient evidence from unnamed plaintiffs to suggest that, yes, you can extrapolate from the named plaintiffs to unnamed plaintiffs, and that would justify certification. That didn't happen here. In fact, at the certification stage originally, the plaintiffs didn't submit any evidence, and the reason there was extra briefing is because we pointed out to the trial court plaintiffs had submitted no evidence in support of certification, and they came back with affidavits from their original complaint. So no evidence.
That briefing, no. That briefing lasted about a year, didn't it? The briefing sort of leading into the class certification.
I think that's correct. What I will say, and what I would expect the plaintiffs to say, is that suggests a rigorous analysis, but it doesn't. It just suggests a passage of time. The trial court had lots of briefs in front of it, some of which actually didn't go to certification, some of which went, for example, to the Ask Me and Pacholi cases and how they would impact this case. In any respect, though, the plaintiffs, while identifying multiple and widely varying sources of their own understandings of the MOU, demonstrated that there isn't commonality or typicality. Some of the plaintiffs said, well, I heard about the MOU from this person in response to our discovery requests, or I heard it from the union. Those demonstrate a lack of commonality. What each plaintiff understood and learned about what spiking is individual dependent. More importantly, and I think the greatest failing of the orders, is the trial court failed to analyze each legal claim separately within the context of Rule 23. The court relied instead on the blanket summary of the case and basically certified by summary. That's completely antithetical to Rule 23. Nothing in the trial court's ruling suggests that the court conducted a rigorous analysis of the elements of each cause of action to determine that they could be tried fairly, both to non-named plaintiffs and to the defendants, by pure extrapolation. The trial court's analysis did not comport with Rule 23, and for that reason, the case is subject to de novo review. Even if this were not so, the trial court clearly abused its discretion by certifying claims on this particular record. Remember, plaintiffs' collective theory is that there are collective bargaining agreements, they are contracts. Those contracts were individually accepted by each individual when he or she signed an election form. This, by its very nature, posts a host of differences between and among class members. For example, and just by example, because I don't have time to go claim by claim, Consider the breach of contract claim. The elements of the breach of contract are contractual offer, acceptance of offer, damages. Looking at the last element first, whether each plaintiff suffered damages depends on a host of variables, including whether or not the high three would actually result from pension spiking. There are all kinds of variables that would affect whether or not somebody who invoked pension spiking would benefit from that at the end of the day by elevating his or her high three. Things like the timing of an individual's raises, career progression such as promotions or transfers. At least one of the named plaintiffs has been transferred out of the bargaining unit through a promotion. When each plaintiff elected, what benefit each plaintiff elected, when they chose to retire, when they entered the drop, what are the future plans of individuals who are still employed. All of those could impact whether or not the selection to spike would result in increasing the high three over a period of time.
As to damages, does the bifurcation concept, how does that affect the argument that you're just making?
The bifurcation as to the trial of damages, I don't believe impacts in any way whether or not at the certification stage on liability, the plaintiffs have to demonstrate extrapolation as to an element of their claim. As Duke said, frequently you have to look beyond the pleadings, behind the pleadings, and into the actual claims to determine whether or not a claim can be certified. And that's precisely what we have here. Even though damages would be tried separately, the issue of liability includes as one of its elements a showing of damage. And the plaintiffs can't do that through extrapolation. There are lots of questions in terms of even whether or not a particular plaintiff intended to accept pension spiking through an election form such that it would survive the MOU termination. There's lots of different reasons that we've outlined in our briefs, and given time, I won't go through those again, but lots of reasons why a reasonable plaintiff would not say, hey, here's the MOU, I'm going to elect spike, and I fully expect that spiking will continue forever in perpetuity. Things such as what the MOUs say. For example, the MOU says all rights in the MOU terminate upon termination. The MOUs do not say that they create pension benefits because those are governed by PSPRS and the city couldn't do that by statute. So at the end of the day, the question is, what did each individual plaintiff intend when they elected spiking? Did they intend to elect a compensation system that would allow them to continue spiking even beyond the termination of an agreement, even beyond where, in this case, the parties reached an impasse during negotiations?
Counsel, let me ask you on the contract claim, though, is it the subjective undisclosed intent, or is it the objective text that's used that determines whether a claim is viable or not?
Well, I think it's in some respects both, Your Honor, because there has to be a meeting of the minds. So the MOU says what it says, and the question is, did each plaintiff enter into what they are calling a contract when they signed these election forms? And if so, what did they understand the contract to be? We have not debated, nor have the plaintiffs debated, what the city's intention was at this time. The only question is, what do these individual plaintiffs intend? And you can't do that by extrapolation because of the language of the MOU, because some of the plaintiffs undoubtedly did not read the MOU but heard about it from others. What they understood they were agreeing to is part of offer and acceptance. Turning very briefly to, as another example of a lack of rigorous analysis, nothing could be more striking in this record than the promissory estoppel claims. To put things in context, the trial court treated Plea's promissory estoppel claim differently from the Clark plaintiff's promissory estoppel claim. The trial court, with respect to Plea, said Plea should be allowed to prove at trial that the entire class, quote, could have, end quote, relied on the MOU and acted accordingly. That's a clear abuse of discretion, and it's just wrong on the law. The promissory estoppel claim requires reliance in fact, not in theory. In order to prove promissory estoppel, you would have to probe as to each plaintiff what they knew, whether or not they relied on the promise, whatever that promise might be, and what their detriment is. In this case, multiple plaintiffs, named plaintiffs, have already said through discovery that they didn't rely. And that evidence in and of itself shows that there are individualized questions on a plaintiff by plaintiff basis. Likewise, some of the plaintiffs through discovery said we didn't rely to our detriment. For example, one of the named plaintiffs said that she didn't use her vacation or sick time because she wanted to store it up to raise a family. Another named plaintiff said he wanted to store it up in case of a catastrophic event. That's not detrimental reliance. That's a reliance for a personal reason. And that's why it would have to be done on an individualized basis and cannot be extrapolated. I think that the last thing I want to say is with respect to the notice of claim statute, Rule 23B3 certification is foreclosed because the plaintiffs failed to comply. To this very day, Plea has yet to serve a notice of claim. We don't know what they are willing to settle for. We don't know the amounts of their claims. With respect to the Clark plaintiffs, they did what they were not allowed to do, which is sue first, then serve a notice of claim. They've tried to cure that by filing a subsequent lawsuit, but that lawsuit just repackaged the old claims. I don't think you can circumvent 12A2101 in that fashion.
And didn't the Superior Court, though, address that issue on a motion for judgment on the pleadings?
Yes, the trial court it infused into the issue things that aren't relevant to the question of a notice of claim, such as we should have known what the value of the claims were, or we did know what the value of the claims were. Strict compliance is required, and regardless of what the 12C ruling was, it still forecloses 23B3 certification. I think at the end of the day, the way to look at this case in terms of the rigorous analysis is to look at what the trial court did and didn't do. It relied on a 60-foot view of the case that ignored the actual issues in the case. It relied heavily on affidavits that wouldn't stand muster in any legal proceeding, and certainly do not shed light at all on any unnamed plaintiffs, what the unnamed plaintiffs' intentions were, what their understandings were, or what their alleged damages were, or that they were even damaged in the first place. The trial court overlooked plaintiffs' own discovery responses that specifically demonstrated a lack of commonality or typicality. The trial court failed to analyze certification in the context of each individual cause of action, which in itself is a cause for reversal, and it led to certification by summary. The court granted certification on some claims without determining whether they were worthy of certification, such as Clark plaintiff's promissory estoppel claim. The trial court strangely said, well, it's a parallel claim, so we'll just throw it into the mix and certify it, and we'll figure out what to do with it at trial. And finally, the trial court granted blanket certification, even though the case is bifurcated. These and other missteps constitute a clear abuse of discretion. We respectfully ask the court to reverse the certification and remand with instructions to proceed as individual cases. Thank you.
Thank you. And Mr. Dorn, I have you having about 3 minutes left for rebuttal, just according to my clock. Now, Mr. Pang, Mr. Wilson, I forgot to ask before we started, are you splitting your time? If so, who's going first?
Yes, Your Honor, we will be splitting our time, although I think Mr. Pang's going to discuss some of the standard of review issues, so maybe it's best he goes first so I don't chew up his clock.
It is your 20 minutes, so Mr. Pang, you may proceed.
All right, thank you, Your Honor. Thank you, Eric. May it please the court, my name is Michael Pang. I'm an attorney at the law firm of Yen & Filch, and I'm here on behalf of plaintiff appellee Teresa Clark and others. For the purposes of this appeal, Clark plaintiffs represent Phoenix Police Department sergeants and lieutenants, and specifically those who were participating in the wage enhancement program on or before July 1st, 2014. Just to start, the standard of review for this appeal is clearly abuse of discretion. It's not de novo review. This court has held that the issue of whether a suit should be allowed to proceed as a class action is left to the trial court's discretion, and absent an abuse of discretion, we will not interfere with the decision of the trial court. The city, in its opening brief, doesn't cite to any cases that apply de novo review to the issue of class certification. All of the Rule 23 cases that the city cites reviewed class certification for abuse of discretion. None of those cases applied de novo review, including the Ninth Circuit case that the city cites as a basis for de novo review. In addition, many of those cases that the city cites state that trial courts not only have discretion to certify a class, but that they have broad discretion to do so. Under the framework of an abuse of discretion, to the extent that the trial court was required to conduct a rigorous analysis of Rule 23, the court's class certification ruling shows that the court did just that. As Mr. Dorn mentioned, and Your Honor, as you mentioned, the motions for class certification have been before the court for at least a year, and that's not just evidence of the passage of time. The class certification ruling itself begins by outlining an entire procedural history of those motions, which include over 165 pages of briefing and supplemental briefing, many exhibits, and 2 full oral arguments just on the issue of class certification.
Mr. Pang, let me ask you about the Clark plaintiff sought certification under 23B1B and 23B2, correct? Those 2 bases. Help me understand the 23B1B certification. It seems to me that that's really largely targeted at limited funds cases, and this is not a limited funds case as I see it. What's your best authority for the thought that certification under 23B1B was appropriate here?
You know, I think, as the court mentioned in its class certification, under the Rule 23B1B certification is a question of whether prosecuting individual causes of action would create risks of adjudication that would be dispositive of other interests of others who are not parties to the individual adjudications. And I think this goes to the question of individuality that Mr. Dorn mentioned in his arguments. The city says that it's an oversimplification to say that all of our plaintiffs' claims are based on the same contractual agreements or the same promises, but I think really what it comes down to is that as far as individuality goes, all of these claims and all the injuries that the plaintiffs and the class members experience in this come from one contract, in Clark Plaintiff's case, the 2012-2014 MOA, that applied equally to all of them. And as the court mentions in its class certification ruling and in the minute entries that it incorporates into that ruling, if the city breached that contract with regards to one individual plaintiff or one individual class member, it breached the contract equally to all individual class members who would be involved in this action. So I think as far as a question of whether there would be adjudications of dispositive interests of others, I don't think that that's an issue here, and the court clearly addresses that in its ruling.
And what published authority, though, do you have that suggests that's an appropriate use of 1B? Because it really does, outside of ERISA claims, which this is not, thankfully, and outside of limited fund cases, 23B1B doesn't seem to have much reach, and that's what I struggle with.
Right, and I know we cited 2 cases in our opening brief, and I would have to refer to that again to find those cases for you.
And let me ask you, and of course we have those, and I'll look back against them. But if in fact, if the city breached one time, it breached as to all, does that undercut your need for class certification?
I don't think it does. I think that enforces a need for class certification. This is an issue where the claims are common to all plaintiffs and all class members. It's the same contract that applies to all of them, the same benefits that they have applied for, and the same kinds of injuries that they're all suffering. So I think as far as an issue of individuality, I think it speaks to commonality and typicality in this case as well.
And I understand that, but again, in the context of B1B, which means by definition, you've gotten beyond 23A. Right?
I'm sorry, could you repeat the question again?
Sure. We don't even get to 23B1B if you don't have typicality, commonality, the 23A factor. So what I'm really honing in on is the Clark classes claims that were certified under 23B1B.
Right, and again, I know we addressed that in our briefs. I would also mention too that the court did certify this under 23B3, and again, as the city mentions, although we didn't mention that in our motions for class certification, that's also another element of Rule 23 that we did address in our briefs. And again,
and so So your claim is that even though your clients didn't seek certification under 23B3, that the court sua sponte certified the Clark class under 23B3?
In their ruling, I would say that they did. They did not distinguish between those sections, between the groups of plaintiffs in this case. The city filed a consolidated response to plea plaintiffs' motion for plaintiff's class certification. In our reply to that, we addressed it as if the court and the city were applying both of those sections to all plaintiffs in this case.
But just to clarify, your motion for class certification did not seek certification under 23B3.
Correct. But I would say that this class certification ruling itself does not distinguish between the groups of plaintiffs as far as the sections of 23B that the court was granting class certification. Just quickly with regards to the other requirements of Rule 23, I know the city mentions that the trial court was required to describe evidence in its class certification. Again, the evidence here is the contract itself. For the Clark plaintiffs, the 2012-2014 MOA and the corresponding election forms. I know the employment agreement that plea plaintiffs bring their claims under, the provisions in that are substantively identical to Clark plaintiffs. And the class certification ruling, it consistently refers to these contracts. It consistently refers to the wage enhancement program. And I don't think there's any confusion what exactly the court is referring to when it says the contract, in this case, again, the MOA, or the wage enhancement program, specifically 3 provisions of that MOA. And you know, the court describes these documents as being the same for all plaintiffs. The class certification ruling even ends by saying that the written documents used to memorialize participation in the program were the same for all class members, and signing the documents shows the intent of each member to receive the benefits offered. And you know, as far as their intent goes, again, the documents were all the same for all class members who signed it. Their intent could not have been anything other than what was specifically written on the election forms. The language of those election forms clearly mirrored the language of the provisions in the MOA. So, you know, I don't think there's any question that the court is referring to evidence in its ruling, and that evidence applies equally to all class members and to all plaintiffs in this case. The class certification ruling directly quotes from Rule 23A and B. The city does not argue and cannot argue that the trial court applied the wrong rule to the issue of class certification, or that the trial court somehow misunderstood the language of the rule that it quotes verbatim in its class certification ruling. Because the standard of review for class certification in this case is for abuse of discretion, and because our trial court did not abuse its discretion by issuing its class certification ruling, this court should not have to decide any questions of law that the city presents with regard to how the trial court should have ruled on elements of Rule 23. And our feeling is that de novo review is not appropriate for this appeal, and because the court did not abuse its discretion, that this court must uphold the class certification ruling. I'm happy to answer any other questions that you have. Otherwise, I'll yield the remainder of our time to Mr. Wilson and plea plaintiffs.
Let me look to my colleagues. Any question for Mr. Pang? Very well. Mr. Wilson, I have you about 10 minutes and 30 seconds.
Thank you, Your Honor.
To go, sorry.
Thank you, Your Honor, and may it please the court, I'm Eric Wilson on behalf of the Phoenix Law Enforcement Association and the individually named plaintiffs, Jacobs, Ackrey, Ramsey, and Flum, known as the plea plaintiffs. The Superior Court did not, first of all, we do agree that with Mr. Pang's analysis that de novo review is not appropriate here, and that the Superior Court did not abuse its discretion in certifying this class, and it's entitled to that the deference as it pertains to the rigorous analysis finding that the Rule 23 prerequisites are met. Now, the Superior Court's ruling was not as brief and conclusory as the appellants would like you to believe, and truly they refused to get into the weeds, and if I'm going to use the analogy to the 60,000-foot view, they just refused to get down to each blade of grass because the common issues do predominate. They've heard, the lower court had heard all these arguments before, ever since the case began in 2014, and you've got that in the record before you. But it's noteworthy also to note that during oral argument during the class, once the Superior Court noted that the evidence or that these issues the city brings now and again were lacking, the court asked for supplemental briefing, and that's a clear indication that it took its job seriously, performed the rigorous analysis that's necessary. Now, the 3 points that we're going to make, as our briefs indicate, are that the Rule 23 class requirements were supported by the evidence, that the certified class is capable of class-wide damages relief, and that the Superior Court did not abuse its discretion in rejecting, in the multiple rulings, the notice of claim defense raised by the city. Before I get into those, though, there's two very important procedural matters that on the record below that I think the court should consider, and I believe that was part of the analysis for the Superior Court. Judge, you brought it up in discussing the stipulation to bifurcate, and in that, the parties agreed in November of 2018 that the evidence of liability and damages are unrelated, that there would be no damages discovery, and it would preclude the damages evidence, and we requested to conduct a trial on the damages only if the plaintiffs prevail and the first establishing the defendant's liability are liable. That's the first procedural matter that I believe is important to keep in mind on this. The second, of course, is what I would call the Superior Court's narrowing ruling. The plaintiffs initially moved for certification of 3 subclasses, and after the judge's ruling on June 18, 2019, that's in Internal Record 214, the court ordered that any claim for relief is barred unless the plaintiff was approved and participating in wage enhancement program on or before July 1, 2014. That's a narrowing ruling and now defines a very specific class, a very common class, and it effectively solidifies the predominance aspects of this case. As we get to Rule 23, the lower court, and central to that analysis was this common nucleus of facts based on the undisputed evidence surrounding the class members' claims, specifically that they predominate and that the contracts were formed. There's the existence of obligations within those contracts, being the MOUs and the predecessor MOUs containing the wage enhancement provisions. The city admits as much in the answer, admitting that these are the best evidence as to the parties' written contracts that they engaged in. We have the wage enhancement provisions at issue here, which are clear and unambiguous. They require an eligibility, the forbearance that officers had to go through. They state the value, which is material to the contract itself, and they have what's most important are the durational terms that are expressed in those agreements. Those terms state that the benefits must continue for 3 consecutive years in each one. They allow for a second election up to 6 years. Then we have the undisputed fact that the officers actually engaged in one or more of these. They submitted these election forms, and the election forms are identical to the provisions or mirrored the provisions of the MOUs that state you get this benefit once you satisfy the thresholds for the next 3 years or 6. Then we finally have the partial performance of the city. They paid them pursuant to these wage enhancement provisions up and until July 1, 2014, when we filed the TRO. So those are the common nucleus of facts that really, truly predominate and act as the bedrock for the court's decision in any analysis whatsoever as to the claims and class certification. Now,
Mr. Wilson, let me ask you, you heard me ask Mr. Pang about the 23B1B certification. Do you have anything to add or anything different than Mr. Pang's answer on that point?
Well, the authority we cite is Ortiz versus Fiberboard Corporation, and the court in that case found that the specific cause of actions would substantially impair or impede other members' abilities. Now, we believe, especially take, for example, the contracts case. If the court were to determine no liability as to one plaintiff, it could and it would extrapolate that to any other potential putative class members. And it would substantially impair or impede their abilities to bring any sort of claim after that. But 21B3, the predominance issue and that this is a superior vehicle for doing this sort of extrapolation is where we believe the case should be certified and was by the court.
And I understand that perspective, and obviously when you if and when you get to 23B, you need one of those. But the 23B1B, and I appreciate what you've told me today.
Thank you, Your Honor. I'm glad to answer your question there. As it pertains, though, to the other four prongs of 23A, we believe that they're met, and numerosity, there's 487 officers as the plea plaintiffs that are left in that. The practicable is clear and obvious on its face, just being 487 members. But then moving on to the commonality prong, where I believe is the big ticket item for the city as far as trying to cut against it. The Superior Court correctly found that there are questions of law, in fact, that are common. The common questions of law were analyzing the claims. The court clearly went through although sort of brief contractual analysis as to the elements. It identified that there was the existence of the contract and determined that the cessation of the pensional benefits could result in damages. Now, there can be no question that a damage results if on June 30, 2014, Officer Ackery was making, I believe it was almost 3482 less the next day as a result of this elimination. There can be no dispute. And the other point I wanted to make that the city brings forward is this lack of damages proof, and saying and drawing in these confusions about when an election occurred and how it affects their high three. That ignores the initial expectation interest involved here. By virtue of engaging in these wage enhancement provisions, an officer was increasing their take-home salary every paycheck, irrespective of their pension, irrespective if they were in their high three. Therein lies damages for the breach of contract. Extrapolate that to the fact that they are PRS members, and the city is required to pay the contributions as to what is known as the compensation under the statute, which has been determined in this case. Then we have those additional expectation interests as they relate to the pension.
Let me ask you, though, Mr. Wilson, you're talking really about the fact of damage as opposed to the amount of damages for a specific class member. Is that fair?
That's for, yes, I'm referring to the prima facie elements of the breach of contract claim. Now, proving those damages is complicated, not only because of the bifurcation, but because both parties, all the parties involved here, have taken a crack at a methodology. The city did so far back when, in 2014. It did it when the plea plaintiffs were costing this out during the meet and confer negotiations. It did it during the TRO, where it hired an expert who conducted a hypothetical analysis on what looks like Plaintiff Ackery's information and numbers.
Mr. Wilson, though, let me ask you, and I'm sorry to interrupt, but I know time goes fast.
Yes.
You're not saying that all class members are entitled to exactly the same amount of money, though, right, if they show liability?
No, I'm not. And the case laws in our briefs, and as we cited, specifically states that individualized damages calculations do not render certification untenable, undoable. It does not destroy the class certification here. In fact, it's those individualized inquiries and affirmative defenses that are raised by the city that the court still permits a class certification, like in Godby, like in Garza versus Gamma and 240 Arizona 373. In those cases, the employer, like it did here, wants individual inquiries as to what happened that get down to the nitty-gritty facts, but the courts determined class certification was still appropriate. And so as it pertains to commonality, truly some of those affirmative defenses that the city raises, actually to the extent that they have any merit, which we posit that they definitely do not, they indicate common questions of law that would predominate. And so those can still be brought in a class certification, although they've been brought before and the lower court has dealt with them. But class certification still nonetheless is appropriate. And as the city notes in its reply brief, a common question is one where the same evidence will suffice for each member to make that prima facie showing. And that's what we're talking about when I discuss that nucleus of facts, that same evidence, those same contracts, those same promises. Now, the city alleges that individual intent and understanding of the members is necessary for proving these, but that ignores the collective bargaining scheme here, We are talking about the Phoenix Law Enforcement Association, the certified bargaining for the individual members. Sure, they bring forward their intent to the bargaining table, but these individuals don't actually meet with the city to come up with these terms. Rather,
Mr. Wilson, our time goes fast. I'll give you a little bit of time to wrap up.
okay, I'm very, very sorry, but even so, the court has long held that we construe contracts and give effect to the party's intent, applying the plain contractual language when it's unambiguous. There can be no dispute. They say what they say, and it's the best evidence. As far as typicality goes, and I mentioned Godby. I won't belabor that point. I believe I can point you to those. As to adequacy, the city tries to bring up these potential conflicts among the representatives and the members. But none of those, especially lacking evidence, none of those potential conflicts that could rise to class treatment are specific in nature enough to overcome the predominance, and none of them make it so that any class representative's interests cut against the remaining class members. I believe I've referenced predominance enough. The damages class on class
Mr.
right.
Wilson, I'll give you a couple more sentences, but then your time has expired.
I appreciate the court for accommodating us during this time. Our notice of claim has been set forth. The notice of claim defense has been set forth in the Superior Court's rulings, as well as our papers. Class certification does nothing to that. We would ask that you reject that that argument and find that the court did not abuse its discretion, and we ask that you uphold the certification of our class, Your Honor. Thank you very much.
Thank you, and thank you, counsel. Mr. Doran, Appleby's did have about 2.5 additional minutes, so I'll give you 5.5 for your rebuttal to equal that out. You may proceed.
Thank you, Your Honor. I hope not to use all of that, frankly. There are 3 points I'd like to make. First, this notion from Mr. Pang and Mr. Wilson that the documents prove intent to enter into pension is precisely the mistake the trial court made. The question in this case is not whether these individuals intended collectively to engage in pension spiking. The question is, did each individual, when he or she elected pension spiking, understand and agree that it could or would terminate at the termination of the collective bargaining agreement, which is what the common law says and what the Supreme Court has said over and over, or did they intend that it might continue in perpetuity? That's the intent that's at issue. And the only way you can get to that is on an individualized basis. And we know this from the plaintiffs, because the plaintiffs, in response to discovery, told us they learned about the MOU and what they could and couldn't do with respect to spiking through rumors, not the MOU. And we still don't know to this day what even the named plaintiffs thought in terms of perpetuating spiking after the termination of a bargaining agreement and after the parties reach impasse. My second point is with respect to assuming for the element of breach of contract that these individuals were somehow damaged. First of all, Mr. Wilson's argument that officers the day after pension spiking was limited were somehow harmed economically is brand new. That didn't appear in the court below. It doesn't appear in the briefs. And frankly, it's not true. If the individuals who were part of the bargaining unit opted into the lump sum payments, as the evidence showed below, they would be receiving the same pay as they had below or had before. The only difference is how the amounts were paid. Lump sum means it's not pensionable under the PSPRS. Payments monthly means it was. So there's no change in compensation. So there's no actual proof of damage unless you go on an individualized basis. Turning finally to the standard of review, did the trial court analyze each claim on a claim-by-claim basis? No. Did the trial court rely on foundationless evidence to support the entire bulwark of its decision? Yes. Did the trial court ignore plaintiff's own admissions in the record showing a lack of commonality? Yes. The trial court ran afoul of Rule 23's framework. When a trial court does that, the review is de novo. We respectfully ask the court to reverse the decision below and to conclude that this case is not worthy of certification and remand the case. Thank you.
Council, thank you. Thank you for your presentation today. Thank you for your briefing. You've given us much to think about. We will take the matter under advisement. We'll issue a written ruling in due course. We did have some technical issues with the presentation on our end, but it was recorded and we have the recording, so all three of us will have the benefit of that, I assure you. So thank you very much. Court is adjourned. Have a good day.
Thank you, you too.